Morning, Judge.
Good morning. I'm waiting for Mr. Bitco to unmute and show up here. Mr. Bartholomew, good morning.
Good morning, Your Honor. Let me, I'll text Mr. Vico and see.
I'm here.
Oh, there he is.
Good morning, Your Honor.
All right, let's see if we can't get something done here. This is case number 21-170663. Louis Bartholomew versus MJ Realty Service, PLC. Could I have your appearances, please?
Miroslav P. Volchko appearing on behalf of plaintiff Louis Bartholomew,
Bar number.
P21851.
Mr. Donald?
Good morning, Your Honor. Robert Donald, P4886 on behalf of the defendant.
The record should reflect that present but muted is plaintiff Mr. Bartholomew. We are here today on defendant's motion for reconsideration of my denying the motion to set aside default judgment.
May I, Your Honor?
Oh, please.
So, Your Honor, this matter was, well, when we were last here, plaintiff was not here, so the court set
Plaintiff's lawyer was not here.
I'm sorry, Your Honor. Plaintiff's lawyer was not here. So this matter was set over for today. And prior to our last hearing, Your Honor, defendant was not before the court because plaintiff had told the court and defendant that he was unavailable on the date that the court held the hearing, which I have included with my motion and the email where plaintiff indicated he was not available on that day and indicated to the court that he would be available sometime after May 11th and that the parties would consult and indicate to the court when that would happen. Everything after never happened. So the court held the April date where plaintiff indicated that they were not available. Defendant failed to show up and plaintiff obtained a order and obtained an order. We're asking that the court reconsider that order as pursuant to what plaintiff indicated they were unable to attend that day, and then in turn did attend that day without informing defendant, and then went on to obtain the order when defendant reasonably, I'm sorry, Your Honor.
Donald, what is the palpable error by which the court was misled? That's what's required for reconsideration. Demonstration
and again, Your
Honor,
palpable
error which must result in reversal of decision.
The palpable error, Your Honor, is that plaintiff indicated to the court and to defendant that they were unavailable and misled the court and defendant. And defendant reasonably relied on the fact that, I'm sorry, Your Honor.
I'm a little concerned here. Maybe I'm confused, but my understanding of the way the case has been proceeding, indeed, my understanding of the way I run my docket is that I decide if there are adjournments or rescheduled. Did I enter an order saying that the April date would not proceed?
If you look at your, I'm sorry, Your Honor, if you look at the email,
Is that email from the court?
No, Your Honor, not an email from an order.
The court speaks through its written orders, right?
This court speaks through its written orders, absolutely, Your Honor.
So what I had before the court was a request, not an order, a request to reschedule. The court determined not to reschedule. So how could you, in the absence of an order from the court, decide that I'm going to have my schedule dictated by counsel for the plaintiff?
And Your Honor, again, if you read the email, the
email
of whom? I'm sorry, Your Honor.
The email of whom?
The email of the court to Mr. Vico, the
And what
plaintiff.
does it say?
The email reflected that the court would accept what the parties were going to schedule after the 11th. And I've included that email with the with my pleading, Your Honor.
Let me hear from Mr. Vico.
Yes, Your Honor. Thank you. Let me go back a little bit and correct the record from the prior statements. Both plaintiff and plaintiff's counsel appeared at the hearing on the 27th.
Yeah,
I believe earlier there was a comment that plaintiff did not appear.
No, that was not my comments, brother counsel. But please go ahead.
Well, if it's correct on the record, that's my only point. In addition, Your Honor, the court's statements are well placed. There was no adjournment made by the court that we're aware of, nor was there any court order entered to that effect. And that's why we exercised our due diligence and checked the court website, and that's why we appeared at the hearing. And it seems to me that counsel and both counsel for defendant and defendant could have done the same due diligence, which they apparently didn't do. That's our position, Your Honor.
my problem here, Mr. Donald, is that when and let's go back to the setting of the April date.
Yes, sir.
How did that happen? It happens the way all of my pretrials are set. I say, I want to do this on such and such a date. Is that date okay with each party? And everybody says yes. So this was not a date which was set without agreement of the parties. This date being set with the agreement of the parties, the court issued an order for that date.
Again, if I may, Your Honor,
Yes,
if that is not how that transpired, that date of April. So if you again read the email that the court sent on Tuesday, March 28th at 11:02 a.m., it says, I spoke with Judge Robinson. Please provide at least 2 dates next month for the appointment for your adjournment that is convenient for both counsel. Once I receive those dates, no need to appear to tomorrow's Zoom hearing.
And were those dates provided?
No, Your Honor, because again,
I'm sorry?
No, Your Honor.
Okay,
Those
so
dates
let
were
me
not-
make sure I understand this. The court provided, or should I say my court clerk said, give me 2 dates next month that are convenient with both parties. And if you do that, there will not be necessary to appear. And it is uncontroverted that the 2 dates were not provided. Have I missed something?
No, Your Honor, you are not.
So then again, as usual, I'm confused. An order setting a date agreed to by the parties. Something comes up. An email is sent, a request is made to adjourn that date, and the court's response is, give me 2 dates next month that are convenient with both parties. If that is done, it won't be necessary for the appear for the scheduled hearing.
All right.
2
and
dates
so-
never provided. 2
Yeah,
dates
so
not
then, Your
provided,
Honor,
all uncontroverted. So how do we get to a point where there's palpable error when the order had been entered with the date agreed to by all of the parties? A conditional, if you do this, you can get a new date had been granted, and the if you do this was not done. How do we get to
So-
palpable error?
So again, Your Honor, going back to the email, so then according the plaintiff, not plaintiff's counsel, then responds and says Wednesday, April 26th, and Thursday, April 27th are good dates. And then plaintiff's counsel responds and says that those are not good dates, Your Honor.
So then help me out. And once again, I'm still confused. You were made privy to communications between plaintiff and his lawyer.
I'm sorry, Your Honor.
But you were made privy to communication between plaintiff and plaintiff's lawyer. I'm still missing. I'm still missing the court being provided with 2 dates that were agreed to by the lawyers. I'm still missing that. I didn't see that.
Okay. And again, Your Honor, so that was not a communication between plaintiff and plaintiff's counsel. That was a communication between plaintiff and the court.
Okay.
And then once that communication,
And then what were the dates that were provided to the court? I got it on one side.
all right, so the dates that plaintiff provided to the court was April 26th and April 27th.
And in the way we operate our litigation, who speaks for a represented plaintiff?
The lawyer.
Plaintiff's lawyer.
Exactly, Your Honor. So then,
So again, I'm back to my same problem that the lawyers had been told, if you want a new date, a date different than the dates you had already agreed upon, then you got to provide 2 dates next month that are agreeable to both of y'all.
okay.
Not done. That's uncontroversial.
All right, I think I'm understanding the disconnect, Your Honor. So, Your Honor, on March 28th, when the hearing was the next day, the March 29th date is when the hearing was going to happen. The court never got from the 2 parties a date that was acceptable pursuant to what the court says, where the 2 parties say this is acceptable.
And wasn't
So
that the
there was
condition
never,
of adjournment?
I'm sorry, Your Honor.
Wasn't getting those 2 dates from the parties for alternate dates, wasn't that the condition of the adjournment of the scheduled hearing? That's the point I'm trying to make here. I'm having trouble with your argument, sir.
Provide. All right. I'm sorry. I can read you your I can read the court's email to us again, Your Honor. And it doesn't seem as if that is a condition of, it says, I spoke to Judge Robinson. Please provide at least 2 dates next month for your adjournment that is convenient for both counsels. It doesn't seem from the email, the plain reading of, I'm sorry, Your Honor.
Continue to read the email, sir.
Once I receive those dates, no need to appear to tomorrow's Zoom hearing, which was the 29th.
Those dates.
I'm sorry,
It
Your
is
Honor.
uncontroverted. The court did not receive those 2 dates, sir.
So that means that, and I agree. It is uncontroverted.
Then
So
nothing
then
changes.
so then, I'm sorry, Your Honor.
Then nothing changed. You already
So then,
had a scheduled date. A problem arose and the court said, give me 2 dates next month that are convenient for both counsel. And if you do that, there won't be a need to appear for the hearing.
On the 29th.
Everybody agrees the 2 dates were never provided.
so,
Why then
mhm.
do you believe, in the absence of an order from the court, that the scheduled hearing was not to proceed?
The scheduled hearing was for March 29th, Your Honor. So I agree that if the 2 dates were not provided, the date that on the 28th, because the condition was not met, that 2 dates were not provided, the hearing on the 29th should have taken place, but it did not take place. Neither party appeared, Your Honor. So we are in absolute agreement on that.
Okay, so both sides agree that you disobeyed the court's order. Continue. And again,
So
I'm still looking for my palpable error by which the court was misled. I don't understand how in the face of a written order, failure to appear is a palpable error.
Well, again, Your Honor, so again, using the reasoning that the court has laid out for us, the hearing on the 29th should have happened because the condition preceding did not happen.
Okay.
Further, the court then sets another date pursuant to a plaintiff's email, not what the court has indicated in its email.
Okay.
And the defendant reasonably relying on what the plaintiff, not plaintiffs, or I should say plaintiff's counsel, not plaintiff, saying that I can't make it on this day. And again, then if you read some more, Your Honor, up further.
Did you get an order from the court for the date when you didn't appear?
Did I get an order on the
court scheduling that date?
I did not get an order from the court to appear on the 28th, Your Honor. No, I did not. And again, that is the crux of the matter. Now, I did get an order not dismissing, but from plaintiff indicating that you had dismissed the matter and assessed costs. And I got that from plaintiff. Then I filed our motion to reconsider, which at the time when we were here last, apparently the court did not have, because then the court indicated that they didn't have an order to be reconsidered. So then the court indicated that it would draft an order and I could then ask for that reconsideration at this date today. The palpable error, Your Honor, is plaintiff misleading the court and misleading defendant's counsel as to could they appear that date, then appearing on that date after saying they could not appear on that date. They misled the court and plaintiff's counsel, which, Your Honor, again, using the court's justifiable rationale, the date on the 29th absolutely should have happened because no dates were given. The two dates were not given on the 28th.
Mr. Brico.
Yes, sir. Yes, Your Honor. Are you asking me to reply to that?
I'm asking if there's anything else you want to tell me.
Yes, I fully agree, obviously, with the court's position. And again, no order was ever entered by the court adjourning. I think we're talking about the hearing on April 27th, aren't we, Your Honor?
That's my understanding.
That's mine also. Other counsel keeps referring to a hearing on March 29th.
Yeah, I'm
not sure what that has to do with anything.
Yeah, I'm having trouble with that.
Yeah, I'm glad you are, because I am too, Your Honor. In addition, it was clear that there was a hearing scheduled on the 27th of April, which hearing was held by the court pursuant to its original order. No order was ever given by the court to adjourn that date. And again, exercising our due diligence, Your Honor, and we weren't the moving party. It was certainly incumbent on moving party to perform due diligence and look at the court's docket online, which is what we did, to make sure that the hearing was being held or whether it was adjourned. And again, we saw no order adjourning it. So that's why we performed the due diligence, because without an order, in our opinion, that hearing date stood as ordered by the court.
That's my understanding of how things work.
If I may just briefly, Your Honor.
Yes, sir.
The order issue, and I understand that while my motion is in regards to the hearing in April, the order for the hearing on the March 29th was the order that I am now saying we should have appeared on the 29th. And plaintiff's motion to adjourn that hearing on the 29th because he was unavailable is where we're at. Because on the 28th, before that order that ordered us before you on the 29th, plaintiff asked for another date. Plaintiff asked for another date. Plaintiff then failed to do what the court ordered them to do, which was to give the court 2 new dates to get another date. So then the March 29th should have happened, Your Honor, because plaintiff did not do as ordered and got another date anyway.
All right.
May I have a final reply to what defendant's counsel is referring to as an order is not an order. It was an email. And the condition, as this court has pointed out repeatedly, the condition of the email was never met. Consequently, the April 27th date stood as originally scheduled. This is all pretty straightforward, Your Honor.
Yeah, the problem that we have here is that we have your client stepping out of his lane. This whole confusion is because your client improperly communicated with the court. That's not his business. He has a lawyer. That's the lawyer's job. And that's the whole problem, crux of this whole thing. And although I think it is quite clear that it was incredibly sloppy practice on the part of Mr. Donald to fail to appear for a scheduled hearing for which there was a written order in the absence of an order altering that. The fact remains that the predicate setup for this screw up was your client's doing something he ought not to have done. If your client wants to communicate with the court, then go to law school, get admitted to the bar. This is not the Gong Show. So what I'm going to do is as follows. I am going to reluctantly, because I do not like rewarding sloppy practice, Mr. Donald.
I understand, Your
Grant
Honor.
your motion for reconsideration. I am going to set the matter for a pretrial August the 7th at 11 o'clock. Does that date and time work for everybody?
Give me 1 second, Your Honor. Let me check my calendar. You said August the 2nd?
7, August 7, excuse me.
Sorry. Thank you, Your Honor. Thanks for the correction. That date is fine with me. What time, Your Honor?
11 o'clock, like today.
Okay.
Mr. Donald?
That date is fine with me, Your Honor.
All right. Well,
And-
I'm sorry, go ahead. What do you want to say?
I was just going to say, just so that I'm clear, Your Honor. So the pretrial will that date, the August 7th date, will that be to argue our motions to some, because both parties had submitted a motion for summary disposition? So I just want to be clear what the pretrial date is, Your Honor. That's all.
The pretrial is to just get this file back on track.
Okay.
Because
fine,
we
yeah.
have a situation where, if you recall, the court had already entered a default judgment in this matter.
That is correct, Your Honor.
And when I look at the file, it looks like the last time I looked at the motion, at the default judgment, there was the motion. I didn't see motions for summary disposition. What I saw was a motion to set aside the default. What I saw
Your Honor.
was a request for a debtor's examination. Not the same thing as motion
No.
for summary disposition. And what I saw when I reviewed the register of action is the court denying on April 27th, the motion to set aside the default judgment, saying that there was to be a 7-day order submitted. Then we had the supposed subpoena that was issued for May 25th for the debtor's examination. Then the motion for reconsideration was filed. Then we finally find ourselves here. So the posture, as I understand the case, is that the case is in a situation where the only thing matter to be heard is not a motion for summary disposition. It is a motion to set aside the default judgment. And I'm not understanding where this summary disposition comes from.
That's fine, Your Honor. I will address the default at our next hearing.
So this is a situation. I'm going to grant your motion to reconsider my decision not to set aside the default judgment. I will hear argument on that August 7th date to yea or nay set aside the default judgment. If there are any further communications with the court, they will be from the lawyers only. Do we have anything else we need to resolve today, gentlemen?
Yes, one last, Your Honor. We've been, as you know, there's been a judgment entered in this case by the court, and we've been trying to schedule a creditor's exam resulting from that judgment. Can we address that issue, Your Honor?
Well, let us assume for purposes of our discussion that I decide not to set aside the default judgment in August. What will you have to do? Schedule a creditor's exam.
Correct, Your Honor.
Different by waiting until that time. And again, we have this failure to communicate because we have unauthorized contact with the court by your client. So what we're going to do is Mr. Donald is going to submit an order that is going to grant the motion for reconsideration. And in that order, he is going to schedule for August 7th at 11 o'clock, the defendant's motion to set aside the default judgment. If either of you wish to file any supplemental pleadings on the subject of setting aside the default judgment, the court will be willing to do so. It appears to me, looking at my order dated June 6th, that I had intended to set aside that judgment, but I looked like I wrote the wrong word. It looked like I wrote deny when I wrote, I should have written granted. Why would I assess attorney fees if I decided not to set aside the default judgment? But that'll be heard and decided August the 7th at 11 o'clock. The lesson, Mr. Bartholomew, you want to communicate, that's why you have a lawyer. The lesson, Mr. Donald, is that the court speaks by its written orders. The lesson, counsel, both of you, is that if you have a condition preceding to getting relief from the court and that condition preceding is not met, then the court's original order stands. Is there anything else, gentlemen?
Your Honor, I apologize. I didn't have a piece of paper to write some notes here. Would the court mind repeating its conclusion here?
The order is as follows. The motion for reconsideration is granted. On August 7th at 11 o'clock, the court will hear the motion to set aside the default judgment. If either of you wish to supplement your existing pleadings on that question, setting aside the default judgment, you may do so.
And you also said the defendant is to submit a proposed order.
No, the plaintiff, who is the moving party, is submitting the order.
I'm sorry, Your Honor. The defendant is the moving party.
The defendant is still submitting the order.
I'm sorry, Your Honor.
Defendant is submitting the order,
That's what I thought. That's what I said.
granting the motion for reconsideration,
And setting the hearing.
calendaring the hearing, August 7th, 2023 at 11 o'clock on the motion to set aside the default judgment. That's what any party who wishes to supplement the pleadings previously filed on the motion to set aside default judgment may do so.
Just finishing my notes, Your Honor. Thank you for your indulgence.
Don't thank me, the taxpayers, buy my time. Is there anything else, gentlemen?
Your Honor, if I may, I just wanted to take this time to apologize to the court. I misunderstood because at the time Mr. Velko was in the hospital, I wasn't sure whether he would be able to communicate with the court. I realize now that I should have reached out to Mr. Donald, who would have been able to communicate with the court. So I just wanted to apologize for that misunderstanding. It won't happen again.
Stay in your lane, Mr. Bartholomew.
Your Honor, to expand a little bit on Mr. Bartholomew's comment, both my wife and I did have a serious case of COVID, and we were either in the hospital or in a rehab facility. I don't recall which at that time, but one or the other. And
Okay.
Mr. Bartholomew's comment is completely accurate.
Well, I understood that there was an illness, and that was the genesis of Mr. Bartholomew's communication with the court.
Yes, exactly, Your Honor.
But the fact of the matter remains, it's an improper communication, and it's the genesis of all of our problems in this regard.
Did you ever see the movie, Your Honor, The Cool Hand Luke?
Yeah,
You know the famous line?
what we have here is a failure to communicate.
Exactly.
But it's not a failure to communicate. It's a failure to follow the rules. Those are different
Yes.
entirely.
Yes, Your Honor. Just to finish then, the ruling is a motion for reconsideration is granted, and a hearing is rescheduled for August 7th at 11 o'clock, and defendant's counsel is to submit an order to that effect.
Yes. And the order will also provide that either party, if they wish, not required, but may supplement their previous pleadings on the motion to set aside default judgment.
Yes, Your Honor. I'm sorry I missed that. You're correct. Of course.
Is there anything else, gentlemen?
No, Your Honor.
It's really been lovely, but I have a docket to get to.
Thank you, Your Honor. I
Thank you.
appreciate the time. Have a great rest of the day.
Calling file number 2219813, Reliable Auto Finance versus Desmond Holmes, by a notice dated June 12th, 2022. We adjourned our pretrial on this matter over to July the 18th. Whoops, let me see. That's wrong. July the 10th, excuse me. Your appearance, please.
Good morning, Your Honor. Jeremy Chisholm, P74670. I'm the attorney of record for the plaintiff.
Yeah, what's happening here? This was supposed to be settled with consent judgment, and
We did, Judge, the last time we were here, Mr. Holmes and I had agreed to a consent judgment with a payment plan, and that consent judgment was mailed to him for his signature. We have not received it back yet. While I was back in the Zoom waiting room after you and I first tried to call this case this morning, Judge, I was able to check and see that Mr. Holmes did call Reliable on the 3rd of July and indicated that, by the way, the payment plan was for $130 a month to begin July 1st. He called and indicated that he was not going to be able to make his first payment until July 15th. So he is, as far as we know, he's still planning on following through with the deal that we previously cut, but he needed a little extra time. The collector who spoke with him told him that that was fine and she would note the account, and she did. And so that's where we're at, Judge, but we have not received back that consent judgment. That consent judgment was for a total amount. The prayer for relief, which was $7,597.88, along with costs, brought it to $78.12.51.
Now, he was supposed to pay when?
Our agreement was that he would pay $130 a month beginning July 1st of this year.
And
He
his
called on the 3rd,
cost-
indicating he was going to be late.
Gonna pay when?
He's now going to pay on July 15th.
On the 15th, which is a Saturday.
But I think by the 15th, Your Honor, I think is
Okay.
probably the more accurate
Okay.
way of stating
Then
that.
here's what we're gonna do. I'm gonna set this matter for hearing on July 17th.
Okay.
So either he has executed the consent judgment or we're gonna proceed otherwise. I can't just keep waiting for him to do whatever it is he's supposed to do when he feels like doing it.
Yeah, that would make for a messy situation, Your Honor.
He's either gonna return the consent judgment or he's gonna appear for the pretrial. July 17th at 11 o'clock.
Sounds good, Your Honor.
And hopefully by that time, he'll have done something.
I appreciate it. And I will be here, Judge, and I'll see you.
Good morning, Your Honor.
Good morning. Soon as Ms. Lee comes in here, we can get started.
Okay.
Unmute and turn on video.
Okay.
All right, I think we're ready to start now. We are on the record calling file number 232404442. Kenya Lee versus Asma Alsbury. This matter came to us by way of a removal from the general civil docket. Could I have your appearances, please?
Yes, Your Honor.
Oh,
Go ahead.
Kenya Lee, Your Honor.
Ma'am, I'm not hearing you.
Let me adjust my volume, Your Honor. Are you able to hear me now?
I can barely hear you. Can you speak closer to your microphone?
Yes. Are you able to hear me now, Your Honor?
I can hear you. Go ahead. You're Kenya
Okay.
Lee.
Yes, I am Kenya Lee.
All right, counsel, your appearance.
Good morning, Your Honor. This is Attorney Sharif McCauley on behalf of Asma Albuquerque, who is present here on Zoom.
What is your P number?
83499.
83499.
Yes.
All right. Well, let me, before I go any further, let me bring Ms. Lee up to speed here. The matter was started in the small claims division. The small claims division is very different than general civil. When a matter is started in the small claims division, either side has the right to remove the matter to general civil. In the small claims division, rules of evidence except privilege do not apply. In the small claims division, the court is not required to follow the case law or statutory law, but is to do instead, quote, substantial justice. All of that is very different where we are now. This is the general civil division. In the general civil division, the rules of evidence do apply. In the general civil division, the court must follow the court rules, must follow the statutes and the case law. So I say that to you because I want you to understand that this is now a much more formal situation than you had perhaps anticipated when you started your complaint in the small claims division. In the small claims division, lawyers are not permitted. In the general civil division, again, which is where we are now, if you want to have counsel, you have a right to retain counsel and have counsel file an appearance, just as the defendant here has done. So that's what I want to make sure you understood.
Yes, Your Honor. I actually had, after it was removed, I did obtain counsel. However, upon entering everything at the counter, my counsel did not receive anything, and so he did not file an appearance. So I don't know if at this point I could request to have the case heard when he is present. And it's
Who is the lawyer?
James Klemansky. And
All right, this is what I'm going to do. Real simple. I'm going to adjourn today's pretrial to August 7th at 11 o'clock. Have your lawyer file the appearance. The appearance is a document by which the lawyer says he or she is in the case. Unless and until that has been filed, you are proceeding in pro per. Now, the other matter before me is what about the answer on behalf of the defendant? What's going on with that?
Did you not receive that?
I don't have it in my file here. And
we
looking,
never, we
looking
never
at-
received it either.
looking at the
Didn't receive it, Ms. Lee?
No.
looking at the register of action, the last thing that I have here is the notice of the pretrial, the removal, and then a motion. I have no.
So the answer, I emailed it as well to Brandy, after I mailed it to Kenya as well.
When,
And send it again. We have till August 7th, so I can definitely resend it again. But it should be in, for sure, your email. But also when I sent it, I wasn't sure about that because we were having mail issues. So I made sure to email it to you as well. And I can resend to her. Let me think. The other thing is I didn't receive information for this hearing as well. So I think we're having some issues there.
you would not have received it because you hadn't filed an appearance.
Well, I filed to remove, in which I then put on there that I was her attorney. So sometimes that goes in lieu of the appearance. I can file an appearance as well.
The
request for removal?
I'm looking for it. It does not, for whatever reason, seem to have made the file. What I got was a transmitted a note from the file on the register of action saying that a removal was signed on or about June 8th. But when I look in the file, I don't see it.
Yeah,
But
so that
in any
was
event,
at the court in person.
yeah, okay. I see it now, but for whatever reason, did you file an answer?
Yeah, so I did file an answer and I sent it to her as well. I haven't